and welcome to the Washington Farm Bureau Update, a podcast designed to provide the latest agriculture, legislative, and Farm Bureau information. Well, hello, everyone. This is Ben Tyndall, and I want to thank you for joining me and tuning into this conversation. Well, if you have been in touch with any sort of agriculture news lately, you couldn't have missed that this past week, on Thursday of last week, the Washington Supreme Court issued their decision on ag overtime. The courts came out on Thursday, conveniently 2 days after the election. Anyway, the court was a rather split vote, 5-4, but they voted against the Deruyter dairy, which by way means they voted against agriculture. So the Washington Farm Bureau, we have been working to pump information about this ruling. We have also been involved with this court case really since the beginning. And Bre Elsey, our Associate Director of Government Relations, is here with me. She is also our resident expert on all things labor here at Farm Bureau. And we're going to have a conversation about this and talk about this ruling, what the next steps are, as well as how this impacts our members. So tell us a little bit about the background of this issue. How did this issue come about?
Thanks, Ben. And this issue is a little bit confusing because, there's a legislative component, there's a constitution component, then the courts step in, and then there's, of course, that practical application. So in 1959, agriculture was allowed an exemption for overtime. And we weren't the only industry that was allowed to have that exemption. I mean, real estate agents, salespeople, railroad employees. There were several industries that have very similar exemptions.
And what was the rationale behind that exemption?
It's really for agriculture. It was the seasonality of what we do. I mean, it's really feast or famine. You might be working all night one day, and then you might have a lot of downtime, maybe in the winter. And those other industries that also have an exemption have very similar qualities. And what I like to say is they really don't fit the box. There's this 9-to-5 box that the legislature likes to fit all employment into. And there's things like sales folks and newspapers and real estate agents and agriculture that don't fit into that 9-to-5 box.
Sure.
And so the legislature recognized that. And they said, you know what, we're going to have to carve you out. Not because, you shouldn't follow employment law, but because the nature of your work just is never going to fit in that box.
Right. And
luckily, in 1959, the legislature recognized the nature of our work and granted that overtime exemption. So I think there's this common misbelief, that in some way they're not paid over 40 hours a week. That's not the case. You're paid for your work over 40 hours. You're just not paid time and a half.
Oh, okay.
And so that's the difference right now with employment law when you have that exemption.
Okay. So tell me, how did this case thing come about? So this case is relatively new. It's not 1959. So how did this case come before the court?
So Deruyter Dairy had some employees that decided to sue over several things. Okay. Some of it was meal breaks or comp time. And part of the issue was their ability to have time and a half for overtime. The other issues, kind of the periphery issues, were settled in a lower court, but this one issue remained. Do they qualify for overtime? And that had to be elevated to the Washington State Supreme Court because that was a question of constitutionality. And so the question that ended up being before them was, did the legislature have the authority under the Washington State Constitution to offer an exemption to the Minimum Wage Act? And so that was the question before the court. Unfortunately, and really a terrible decision, one that's probably the biggest decision that agriculture has ever faced, we did lose. In a 5-4 decision, the majority said the legislature did not have the authority. And the weird thing is they didn't say that the legislature couldn't revisit this issue. They just said that the intent, the way they explained why that exemption should exist, was flawed. Now, the decision goes on to become more radical. And this is the part that's really pure baloney on behalf of the justices.
Yes.
In a dissenting opinion, they really focus on inherent racism. So in 1959, under Jim Crow laws, they have stated that the law itself is inherently racist. And the peculiar thing is that the decision says, and we affirm, that the working demographic at that time was actually majority white. And they don't actually deny that in their language, but they say that the majority of workers now are not.
It doesn't fit the activistic rhetoric that they want to present in this opinion.
Right. And there's all these conflicting statements in the decision. And I think that's what frustrates us the most is that even though they acknowledge the fact that we didn't have a majority of workers in a minority capacity, Latinx or whatever it is, and that exists today, because in 1959 it was a Jim Crow era, all of a sudden these laws are inherently racist. And what I worry about are the other folks with exemptions, or the other laws that were passed in 1959. Does that make
a good point? Does
this set a precedent where every time we question a law and it happened to be passed in the 50s or 60s, it has to be, reviewed under this new precedent of inherent racism?
Yeah.
And I think that's a slippery slope that's not only, radical, but it's just this legislating from the bench type perspective. And that's exactly what you don't want, because it's not based in fact at that point. So are real estate agents racist?
Right.
Are locomotive engineers racist?
Yep.
So what is this going to do to some of those other exemptions moving forward?
Absolutely. So tell me, what has Farm Bureau's role been in this process?
Yeah, that's a good question, Ben. So Farm Bureau became an intervener in this case. And to do that, we actually had to petition the court, and we had to be granted that status. But an intervener isn't just like an amicus brief, which is more of a friend of the court where you just supply friendly facts. An intervener actually makes you a party to the case.
Right.
So those legal foundation dollars that are donated by farmers allowed us to hire an attorney and actually become an official party to this case.
Okay.
And that will be really impactful as we go down the road, because it also gives us the ability, again, to be a party to the motion to reconsider. And so we can do that even independently, because we're not an outside, periphery item here. We're actually a party.
Okay. So in essence, regardless of what Deruyter Dairy or what the Deruyter family wants to do, if they want to move forward or not, Farm Bureau, we have the authority to continue this issue regardless, and we can continue to press the court for, some clarification on those areas that are vague or that we see as unjust.
Right. And that's where you'll see those legal foundation dollars go again.
Right.
And again, it offers us the ability to hire that attorney, to file that motion to reconsider, and continue to exhaust every legal option we have to continue to try to flesh out this ruling and to get real and definite answers for things that went unanswered in the original ruling.
Okay. So now you mentioned that this is a constitutional issue. Explain that a little bit, because in my mind, this is a legislative issue that the legislature passed a bill that made this legal. So the legislature then needs to determine it. How is this a Washington state constitution issue? And if it is a constitutional issue, does that mean that the voters then have a say in how this is decided?
They don't. There's only one level of recourse, and that's to ask the court for a motion to reconsider.
Okay.
And in essence, they would have to admit that they were wrong in some capacity, which of course is an incredibly high bar to get over.
For the courts to determine,
So we have legitimate questions we feel were unanswered in the decision. And the decision was strange. The majority opinion was 5-4, but then you have a dissenting opinion by Gonzalez. That's kind of the real radical opinion. That was a 3-person decision. But then you have this dissent that's a 4-5. And it's almost like you had one justice kind of on the edge of, indecision. They weren't sure which way they were going to go. And the remarkable thing, too, that really leaves a terrible taste in your mouth is that this decision was published 2 days after election.
Funny.
Yeah. Conveniently, several of them were on the ballot.
Yeah.
And so we don't know what impact that had on the decision, but it looks very likely that you had one waffly judge, because even the dissent is better written. It's longer, it's more thorough, and it just calls into question, what happened there and how much did the elections weigh on whether or not they were going to go with what's now the majority opinion or the dissent.
Yeah. Lady Justice was peeking under her blindfold, looking at the calendar.
Right.
Oh, well, we'll hold off on that decision till Thursday. Let's let Tuesday work its way through, and we'll see who's left. So the decision was made. We may not like it in general, but it was made. So now what is the fallout? Explain how it affects agriculture, because this was initially focused on dairies, but it has implications all across agriculture, and we're all agriculture is getting lumped into this. Can you kind of break that apart for us?
So the question posed to the court only had to do with dairies. So they were only allowed to answer that question.
Yeah.
However, they wrote the decisions in a way that leaves it open for further litigation. And that's the vague nature of this decision right now. And we have attorneys that are looking over it feverishly. Everybody's got a little bit of a mixed opinion right now. We know without a doubt this impacts dairies.
Yeah.
And so that means in 20 to 30 days, that Supreme Court decision will be kind of remanded back to a lower court. That'll be finalized.
Okay.
And that time and a half will go into effect for dairies, unless for some reason a motion to reconsider delays that maybe by a couple months.
Okay.
But we know the effect to dairies is immediate.
Yeah.
But what the decision did was leave open the room for future litigation, basically for the rest of agriculture to be sued. And we very much anticipate in the next week or so that those lawsuits are going to be coming. The other major issue that the court could not decide, because the question was not before them, was whether or not there was 3 years retroactive compensation.
Yes. Yeah. Talk to me about that.
However, they allude to it in the decision, and they allude to it strongly in the dissent. And that's basically an invitation for class action lawsuit, unfortunately, and that is absolutely terrible. The workers don't benefit here. You know, there's these radical organizations that claim that they represent the worker, but does a worker in reality want only 40-hour week schedules or potentially less pay? And really, when you open this up to class action lawsuits for the potential of 3 years retroactive compensation, the only person that really benefits are these, pariah attorneys, these opportunistic attorneys. At the end of the day, the worker gets almost nothing. And if you were going to ask a worker if they wanted less pay, less work hours, and barely any retroactive compensation, they're going to say no. So this decision really does not help the worker. And that's the real tragedy here as well. So right now, the 3 years retroactive compensation is still up in the air. Okay. It's going to have to get litigated in some capacity in order for it to go forward. But we crunched some numbers, and it looks that about a medium-sized farm could owe in excess of $1 million.
Ridiculous.
It's incredible. So the damages here are real.
And what's the rationale? In my mind, we were talking yesterday. It's like the state determining, we're going to reduce the speed limit on a state highway from 60 miles to 40 miles, and now everybody is going to get speeding tickets for the past 3 years because you were traveling 20 miles over the speed limit. No, we were following the law. We were abiding by the law. If you don't like the law, you change the law. And from here on, the speed limit will now be 40 miles an hour. But you don't go back and tell me I was doing something illegal when I was doing exactly what the posted speed limit was explaining. So what's the rationale behind we're now going to go back and penalize all of you for 3 years for doing what the law allowed you to do? Explain that.
And that's the real
crime. If you can. I don't know if that is even explainable or justifiable.
Unfortunately, this law is on the books. You can seek 3 years retroactive compensation. I think what astounds us is that it's almost never applied.
Okay.
So we're surprised by this, although it's always been there.
Really?
Because it's so infrequently it's applied that we're just shocked, because you're absolutely right. I mean, their only crime is following the law perfectly. Because remember, the decision by the courts wasn't that the farmers acted incorrectly or that they didn't follow the law. The decision on the court was that the Washington State Legislature didn't have the authority to offer an exemption in 1959.
Yeah.
But that doesn't mean the farmer did anything wrong. And if there's any fix to be had here, I think that's priority number one.
Okay.
I mean, there's no way the public or anybody that hears this case is going to think that that's okay in any capacity.
Now, explain that just a little bit. It would almost seem that the legislature would be the first stop, seeing as it was really their law that initiated this issue in the first place. Why wouldn't we go to the legislature first and ask them, can you change this? Can you adjust this before we have to go through all these legal brouhaha?
Yeah, there is an opening for the legislature to act. We don't know at this point if in time if that will be needed.
Okay.
But the court never said that the legislature couldn't fix their intent section.
Right.
Couldn't try to do something to maybe change the language and make it better fit under the Washington State Constitution. You know, if I was a legislator, I'd be furious.
Yeah.
The court has just told you how to do your job.
Yeah.
You know, that's what we call legislating from the bench.
Yes.
You know, these are radical interpretations of the law. And that's the legislator's job to make these rules. That's not the court's job to do this. And so if I were the legislature, I would think, you know what? We have an obligation to fix this. We have an obligation to make this right and take back our control over this situation from judges that went rogue. And so I do think you're going to have legislators who want to tackle this.
Well, it's a very hot topic. This is not something that I don't think a legislator can, at least in good conscience, truly ignore. So it would seem like this is on at least some legislators' radar.
So the opportunity is there, although we firmly believe we have to exhaust every legal avenue first before we get to that point.
Oh, okay.
I mean, it only makes sense to, one, acknowledge to the court that they were wrong, that this decision is terrible and it is not based in fact.
Sure.
But if for some reason that's not successful, the door is open for the legislature to review this and see what, if anything. Now, I don't know if there's political will for that. You know, legislators have not been kind to agriculture.
Right.
What I would request of the folks listening to this podcast is to share this information.
Yes.
We want the public to
Please.
know what happened, and we have to bring attention to this because the public is actually resoundingly supportive of agriculture and farmers.
Yeah.
Their opinion of agriculture is vastly different from that of, you know, attorneys, judges, and lawmakers. So what we do is encourage you to share this information. Let your friends know kind of the travesty of what's happening, because I guarantee you that none of them will think that this is okay.
Yeah. Okay, so we've kind of alluded to it a little bit, but what are the implications of this decision? What can a farmer, what can a dairyman, what can they be doing now to protect themselves, protect their operation, protect the employees, because they do want to provide for their employees. They do want to protect their employees. What can they be doing to make sure that their operation is stable?
Right, because remember, an average dairy worker earns $17 an hour. Yeah. They're not earning $13.69, which will be
above the minimum wage, by the way. Yeah.
And January 1, you know, that'll be the new minimum wage. So they were already earning, you know, on average, well in excess of the minimum wage. So this will only hurt them at the end of the day. So what we've encouraged, you know, farmers to do is get a hold of your CPA. Okay. You know, start talking to the person who develops your scheduling. See what kind of rearranging you can do to fit into the law, even if you're just general agriculture, even if you're not a dairyman.
Yeah.
Take the time. If you want to go talk to an attorney, start figuring out your schedules, start figuring out your books, and then also calculate what 3 years retroactive compensation will look like. It cannot hurt you to be prepared.
Yeah.
You know, if there is a class action lawsuit or in some capacity this moves forward, the thing we want you to do right now is just to have your numbers ready, to be prepared, and to start calculating what the future looks like for you.
Yeah. Okay. We've been involved in this court case really from the beginning. As we're going forward, what is Washington Farm Bureau's role as we're looking ahead?
Right. So our only recourse right now is to file a motion to reconsider.
Okay.
Like I said before, you know, it kind of forces the court to acknowledge that there's unanswered questions. We asked direct questions and they just went completely unanswered.
Yeah.
And that is our only legal recourse at this point.
One of the things we've heard, can this go to the Supreme Court, U.S. Supreme Court? Is there recourse to appeal this and go to a higher court?
You know, and I get that question a lot. And unfortunately, we can't because the Supreme Court is considered the highest power when interpreting Washington state constitution. So they're not saying that this violated federal law. Actually, there's an ag exemption under federal law for the whole United States. But Washington state constitution has their own parameters on employment law. And so the Supreme Court, the Washington State Supreme Court, is really the highest court you can go when you're interpreting Washington state constitution. So unfortunately, this can't be elevated at this point beyond that.
Okay. Now, well, can you tell me a little bit? So for those of you that are listening, a lot of you have probably been getting our emails talking about the Legal Foundation, kind of what it does, encouraging you to get involved, to support through donations, those kind of things. So Bre, can you tell me a little bit as far as what is the Legal Foundation for those that may not know, and they may be getting these emails but not real sure? Obviously, this is a tangible example of something that the Legal Foundation is doing, the role that Farm Bureau has through the Legal Foundation to make an impact on this issue. Tell me a little bit about what the Legal Foundation does.
Yeah, so the Legal Foundation is our legal arm, and it's 100% donation driven. So our ability to hire an attorney and fight all sorts of cases depend on the funding of that legal foundation. So we have had folks reach out to us and say, Bre, how can I help? Well, there's only one last legal remedy here, and that's that motion to reconsider. But we need legal fund dollars in order to pursue that. And the turnaround is really tight right now. There's only a 20 to 30 day window where we can even file this motion to reconsider. So not only do we need legal foundation dollars in order to do that, we need them immediately. So if this is something that is interesting to you, you want us to continue to go on that fight, please look at our website, look at the Legal Foundation link. And if you're so inclined, we would really appreciate your support.
Yes. So you can go to the Washington Farm Bureau website, www.wsfb.com. And on our website, you'll be able to access the Legal Foundation, be able to make donations online. You can also send donations via check to our office if you want to go that route as well. And with that, we will call it a day. I appreciate you listening in. If you have any questions or if you want to make comments on this to our office, our staff, please reach out to us. You can contact us either via website at www.wsfb.com and contact us. Our contact information is all there, the different staff members. If you want to have a question, if you have a question about the Legal Foundation, what we're doing, please reach out to us. Give us a call at our office. We would love to hear from you. If you have any questions that we can help with, if you have any questions about this particular case, or if you're a farmer who may be impacted by this, know that we will keep pressing on this issue as we want to advocate and support you, our members, and the agriculture community in Washington State. We would be glad to hear from you. The WFB Update is a production of the Washington Farm Bureau, the voice of agriculture in Washington State, ensuring our family farms continue to feed the world. To learn more, visit our website at www.wsfb.com.